Well, welcome. Thank you for coming today. This is Housing Choice Vouchers and Other Sources of Income. We're going to talk about new protections for renters. And this training is made possible by a generous grant from the Michigan State Housing Development Authority. So we're grateful for that. I'm Jessica. I'm the Associate Director. That's Nikki. That's Sarissa.
Sarissa also works with us. Okay.
Yeah. And are you with Trinity?
I am. I'm Mallory, one of the community health workers at Trinity.
Awesome. Well, thanks for being here. I hope this is a good, good informative session. You know, we'll keep it fairly low key, but if you have questions or anything, I mean, throughout, just feel free to interject at any time. Same for you.
Okay. I was going to do it anyway.
Okay.
Keep us on our toes.
Yeah. So the goal of this training is to provide a working knowledge of source of income protections, so you know where to turn if you or someone you're working with suspects they've experienced housing discrimination. So we're going to cover fair housing centers, fair housing laws, source of income protections, and then we're going to go into some case examples and a few other emerging issues before we talk about how to take action. Okay. So the Fair Housing Center of Southeast and Mid-Michigan is a nonprofit organization that enforces federal, state, and local fair housing laws. We do this through undercover testing. We provide advice and advocacy services. We refer cases with evidence to to cooperating attorneys, and we do community education like this. And our mission is to end housing discrimination and promote accessible, integrated communities. We are one of 4 independent nonprofit fair housing centers in the state of Michigan. So we're based in Ypsilanti. We have a satellite office in Lansing. But we make sure that every complaint is addressed. So you can see the state is kind of split up into a few different colors here. We've got our service area is in blue, and then all of those counties that are outlined in blue are not technically part of our service area, but we will field those complaints or calls if they come in from that area. Our colleagues in West Michigan are in the orange. They're based in Grand Rapids, and again, they cover the outlined in orange as well. And then there's a fair housing center in Kalamazoo and one in Detroit. And there's a fair housing department at the legal services office in Flint. So that's the dark green there. So each year we take about 200 complaints lately. Our typical, a typical year, we typically see race and disability kind of flip-flop for the top protected class that we hear about. But with the new source of income law, which is why we're here today, we actually saw a huge increase in source of income complaints last year with over 80. So that surpassed everything. But physical, mental, emotional disability, and race are always at or near the top. So, sorry, I took it. So we're going to talk a little bit about the laws that provide protections. So the Federal Fair Housing Act bans discrimination based on 7 federally protected classes: race, color, religion, national origin, sex, disability, and familial status. And this applies to all housing-related transactions. The Elliott-Larsen Civil Rights Act adds protections for age and marital status have been a part of Elliott-Larsen for a long time. Sexual orientation and gender identity or expression were added a couple of years ago. And then as of April of 2025, source of income is now protected in the state of Michigan. And then I pulled some additional protections for the city of Ypsilanti, the city of Ann Arbor. So here in Ypsilanti, they have additional protections for educational association. We usually refer to that as student status. Felony or misdemeanor convictions, there is extra language you can see here that basically, unless there's a direct relationship between the conviction and like the housing, or to accept the person would create an unreasonable risk is what the ordinance says, and immigration status. So these are in addition to federal and state protections here in the city of Ypsilanti. Whereas in Ann Arbor has most of those, they have arrest record, educational association, family responsibilities, genetic information, HIV status, which kind of falls under disability anyways, but political beliefs, veteran status, and victims of domestic violence or stalking. So again, these are enforced a little bit differently usually, although we'll talk about that as well as we go on. I'm getting ahead of myself. So let's talk more about the new source of income protections. So source of income discrimination is refusing to rent to someone or treating someone differently based on their source of income. And protected sources of income are basically any lawful legal source of income. So things like Social Security disability income, SSI, and of course Housing Choice Vouchers, formerly known as Section 8 vouchers. Other things might include alimony, child support, state emergency relief, things like that. So we've seen this going on for a long time, right? There was a need for adding source of income protections to the law. And source of income was protected in some municipalities, including Ann Arbor and Ypsilanti, prior to this state law. So we got complaints. We know what it does. We know that it shrinks the pool of available housing and it limits housing choices. It creates patterns of segregation or perpetuates patterns of segregation, and it results in concentrated poverty throughout our communities. It increases housing instability. If someone can't place a voucher, it increases their rent burden or may result in homelessness, or more typically you'd end up with substandard housing, right? Our former director would call it the housing of last resort. And then obviously there's, I shouldn't say obviously, but there's a disparate impact and a connection between people who experience source of income discrimination and historically marginalized communities, including women and people of color and people with disabilities and families with children. I don't know the exact stats, but I do know that most of these groups of people here make up the majority of voucher holders. So, hooray. After a hard-fought battle for a few years to add this to state law, the governor signed this into law and went into effect on April 2nd, 2025. Michigan landlords can no longer deny renters the ability to use their housing choice vouchers. We will get into caveats, but. So this new protection says that, in this case, persons means basically housing provider. But the law uses the word persons with 5 or more units cannot, based on or because of source of income, deny someone housing, have unequal terms or conditions for rent, misrepresent housing, so they can't tell someone, oh, we don't have anything available, or to discourage someone from applying when the reality is that they do have something available. And they cannot retaliate against any person for asserting their fair housing rights. And that applies to all aspects of fair housing law. So source of income discrimination, honestly, it's a little more blatant than some areas of the law because it's newer, right? So, 30, 40 years ago, we might have heard statements like, oh, well, we actually have, right? One of our first cases was a Black family who was denied the opportunity to rent a home in Ypsilanti, and testing showed that they told a white family, you know, I'm sure the Codringtons, I'm sure they're great people, but I only want to rent to white people, right? We don't hear that overtly as much anymore. But source of income, we do, right? We will hear, sorry, no Section 8. They'll come up with excuses why they don't need to work with it. Like there's just too much paperwork, or we don't want to go through the extra inspection. Someone might say that we don't enter into third-party agreements, or they might say that they will have to increase the rent amount in order to accept a voucher. Last but not least, of course, if you call fair housing, I'll evict you. It's not legal, but that is, you know, these are all things that we've heard in practice, you know, from real renters. Yes.
Yeah. So this just makes me think of a situation. I was on the phone with a client and we were contacting like a rental property. This I think was before April 2025, and they said, yeah, we no longer accept Section 8 anymore, like it recently changed. So in that sense, had it been, you know, after the laws have changed, would that have been like discrimination technically?
Absolutely.
Okay.
And depending on where it was, it may have been, you know, protected at the time.
Okay.
Federal law has been a little bit back and forth on this. So, you know, a few years ago, we could also look at these cases under federal law because it has a disparate impact on money protected classes. We don't currently have that tool at our disposal according to the federal government, but we do have this state level protection. So, but absolutely, if they say no Section 8 or we don't enter into we keep hearing the third party contract one a lot, then yes, absolutely. And so we'll talk about how you can connect your clients or patients with us, you know, at the end, but really it's just a matter of giving us a call, or you can initiate it, you can give our information, you can call together, anything like that.
And you think it was like a bigger landlord? They probably had more than 5.
It was literally Camelot Apartments off of Washtenaw, so
Yeah.
We know all about that.
All right. Yeah. So, for the group, true or false? A landlord with 3 units in Michigan is exempt from Michigan's source of income law.
I can't answer.
True. And true or false, a landlord with 50 rental units can require a tenant using a housing choice voucher to pay a larger security deposit. That is very much false. However, I rearranged things just a tiny bit, so I'm gonna.
No.
So fair housing laws are not self-enforcing. So now what? Fair housing centers can help by taking and resolving complaints of illegal housing discrimination. We help fill the evidence gap, and we are advocates for people who've experienced discrimination. Welcome. I will just pause to say, anyone, please help yourself to pizza or drinks in the back. We have as many pizzas as we have people. Thank you. And if there are any questions throughout, just feel free to interject. Okay, so thanks, Nikki. So this is a very crude flow chart of our process. So I'm going to kind of walk through this, but it'll make more sense when we're going through cases. So I get to do the boring technical part, and then Nikki gets to talk about the case, which is much more enlightening. So when someone contacts our office, they talk with our intake specialist, and she helps determine whether or not there's a potential allegation of housing discrimination at play. If there's not, we try and connect the person with resources that can assist them. I know personally I like to I really want to make sure like I'm not giving someone the runaround, right? Like I get them connected with like the next best resource. So, but if there is an allegation, our intake specialist over the phone will gather information. She'll collect some supporting documents. We do all of this basically phone and email, unless there are extenuating circumstances. Once we get a complaint, our enforcement team will sit down and determine who's going to take it on and what the next steps are. So let's say it is a source of income complaint and the complainant alleges that there are, they said that they said they'd take my voucher, or they said they accept Section 8, but only if they don't have to sign a HAP contract or a third-party contract. Well, that's all Section 8 or all Housing Choice Vouchers require you to sign these third-party HAP contracts. So in essence, they don't accept it. So we take the complaint and we may look into it through testing. Having someone pose as an ordinary home seeker, asking about availability, and we'd have one person with a voucher and one person without, and see if they're given similar treatment, similar information, or see what their policy is on accepting vouchers. So that can be a really enlightening way, especially for source of income, right? Some other types of discrimination are a little bit harder to get at in the testing, or can be a little bit harder to get at in the testing phase, but it is really, really instrumental in source of income complaints. In other cases, we may use any other investigative tools at our disposal. We are a small nonprofit organization. We are not a government entity, so we have unique things that we can do, like testing, but we also don't have, the authority of the federal or state government. So, we do what we can within our our jurisdiction. And so that might be things just like sending out a survey, or conducting interviews, or pulling eviction records, or just any other kind of research. So there's a lot of different ways we might investigate that aren't just testing. And then we do a lot of direct advocacy work. In fact, I think more than half lately of the complaints we get are cases that involve direct advocacy. And most of that looks like requests for reasonable accommodation or modification for people with disabilities. So if someone needs their rent due date changed because they rely on Social Security disability income and it comes on the third Wednesday of the month and they're getting late fee after late fee every month, we can request that the due date is changed because this person cannot work and they rely on disability income and is directly related to their disability. A modification, I'll let Nikki talk about it because they're yes.
Just when you do that request for the date to change, is it just like sending a letter, or what does that look like?
That's what we almost always start with a letter. So we outline, who we're working with, what the request is, why the law supports it, and we try to come, sometimes it's an issue of just misunderstanding, or and sometimes it's an issue of they need a little bit extra push because if it's what we unfortunately find is that a lot of times if an individual makes a request on their own behalf, they may be dismissed or denied, but when the Fair Housing Center gets involved, the housing provider may be more responsive. So in the case that we find evidence from testing or other investigations or our advocacy work, if we do our best to try and come to a solution or a resolution, but we're unable to do so, then we will present our complainant with options for further action. So they're never under any obligation to take action, so they can choose not to. They can choose to have the Fair Housing Center try and conciliate something on their behalf. which in the case of advocacy, we've already done that. But the most likely paths that people take are to file a complaint with a state or federal administrative agency. So that would be the Michigan Department of Civil Rights or the U.S. Department of Housing and Urban Development, or to file a lawsuit with one of our cooperating attorneys. We made it. Okay. So with that, we will talk about some case examples.
Okay. All right, so we'll start with, we're gonna talk about different source of income cases, and we'll start with one from the local, at the local level. So a local ordinance, the city of Ann Arbor has a local ordinance that prevents discrimination based on source of income. So this came before the Elliott Larson added it as a protected class at the state level. So we had a complainant, the woman in the middle, Megan Morse. She was looking for apartments in Ann Arbor to place her voucher, and she was told by many landlords that they did not or would not take her Section 8. We had, prior to, I mean, for a couple years, as Jesse indicated, like this wasn't just an issue that came up, and that's why, you know, right before it was added to LA Larson, we've been taking source of income complaints for a long time. So we had already been testing for source of income discrimination when the person on the left is the head of the U of M law clinic, Mike Steinberg, and that was one of his law students. They came to us and they said, can you do some testing? And we said, sure. And this included some of the landlords where Megan Morse had applied and had been told no. So again, what Jessica was saying, like when we do testing, it's usually to replicate or come close to the situation where a complainant, not always, but if it's a complaint-based situation, that they are treated the same way that the complainant was. And our testing revealed that. So Wilson White was the landlord in Ms. Morse's case, and they told her that they do accept Section 8, but that they don't enter into third-party contracts, which is basically a proxy for discrimination, for source of income discrimination. So you can't accept someone's Section 8 without signing a HAP contract, and that HAP contract is between a third party, which is the MSHDA housing provider, essentially, like around here, Ann Arbor Housing Commission, RPI, CMA, those are all MSHDA contractors. So they were saying they wouldn't enter a contract with those providers, but they take Section 8, which is ridiculous. So basically eliminating her right under the law, under this local ordinance, to use her voucher. So the law clinic represented her, and they filed a case in April of 2023. And she was the first tenant ever to kind of exercise her right to private action, to bring a lawsuit under this ordinance in the city of Ann Arbor. It was very exciting. She was a great complainant. It didn't go to trial or anything, but she would have been a great witness. And so in terms of the damages she suffered for not being able to place her voucher like the law provided her, gave her the right to do, she wanted to live near U of M. Wilson White was near U of M because she was participating in a study. She also has a disability, so she was going to the U of M hospital a lot. And so she wound up having to live much further away. She wanted to live closer to her daughter, who lived with the other parent, and she wasn't able to live as close, so she had more expensive transportation costs, having to go back and forth to the hospital from her further new apartment. So there were all kinds of damages, not to mention the most serious, which were the emotional distress damages and discrimination from knowing your rights, trying to be able to place the voucher and just being told no. So I'm totally forgetting to do this part. The case settled for a non-disclosed amount, and it was really groundbreaking because it showed that the courts were willing to solidify people's rights to private action, that they were able to get damages, and more importantly, also it made the issue public. There was a lot of, there were press releases, U of M, showcased her, and I think the most interesting and coolest part of this case is being involved in it motivated her to want to go back to school and take some prerequisite classes to go to law school herself. So I think that's very neat. Am I forgetting anything? No. Okay. Next case. So this is a case that involves both source of income and federal law, disability discrimination to be more exact. So this woman right here is Deb Patterson, and that picture was taken in 1998, the first time she came to the Fair Housing Center, and she lives and did live at Clover Lane Apartments in Ypsilanti. So the first case that the Fair Housing Center assisted her with had to do with accessibility and modifications. At the time, there was a state law that actually mandated that private landlords had to pay for and provide reasonable modifications. That part of the law is not in effect anymore. But my point is, she knew about the Fair Housing Center and she knew her rights, and she was a very good advocate. This for herself. This was, I think Pam organized this, our former director. So it was basically like a protest or public awareness saying, you know, access is for everyone, honk for disability rights. So it was really something that got the public's attention. So she got the modifications granted in her first case. So fast forward to 2022, I believe, and Ms. Patterson had been living in the same apartment for over 20 years. It had been outfitted with modifications specific to her disability, to her physical disability. She is full-time in a wheelchair. So it had lower cabinets in the kitchen, in the bathroom. It had widened doorways to go through with her wheelchair, and all the thresholds were flat so she could roll over. And she was very independent. She could do everything on her own. So in 2022, she was told by new management that they were going to temporarily transfer her to a unit across the hall. They said that they were going to be doing renovations, not that she asked for these and she couldn't stop them from doing them, but they said it was going to be temporary. So she's in this new unit across the hall thinking she's going to go back, you know, pretty soon. But she asked for temporary modifications because, again, she needed all of these to be able to be independent in her temporary unit, which wound up not being temporary. They ignored her modification requests in the temporary unit, just kind of blew her off, didn't respond. She had her home health care aides and other people assisting her in the house make accommodation requests orally in writing, blew them off too. So as a result, she couldn't stay in that unit because it was dangerous. Like, she couldn't push herself over the threshold, so if they were going to fire something, she would have been stuck. So she had to go live temporarily because she couldn't pay for around-the-clock nursing care, which is what this temporary unit, you know, now was presenting her with this problem. So she had to go live temporarily in a nursing home. And while she was gone, her healthcare worker and her nephew contacted us saying that, you know, all this was happening with the modifications, but also that they told her that the Section 8 voucher that she had been using, that they were no longer going to accept, and oh, by the way, they were also going to increase her rent by $400. So bad, and this is what precipitated her nephew calling us. So we did some testing, we did some source of income testing, and our testing revealed that the unit that she was asking about, which was another accessible unit, that they told her was going to be $400 more than her current rent, they did not tell that to our testers. So they told them the rate that she had been paying. So that was evidence of source of income discrimination. At the time, that wasn't in effect at the state law, but what this case shows, interestingly, is because she had made those modification requests and they didn't want to do them, and they weren't willing to transfer her back to her original unit because they rented it out to someone else, didn't tell her, someone else who didn't need the modifications either, by the way, that they were trying to get out of doing the modifications by just saying they wouldn't take the Section 8 anymore, and that's retaliation. So we had a pretty strong federal case on the disability discrimination not doing the modifications, and then also trying to evict her as a result of asking for them by saying we don't take Section 8 anymore. And then on the advocacy kind of state action piece, we contacted MSHDA and we said, well, we know they can't increase the rent that much, but we made a reasonable accommodation request for a disability for them to increase the payment standard. And when they factored in all the numbers, and it did wind up going up like $130, not $400. So she was able to stay. She was able to enter into a 2-year lease at that point. She is still there. I mean, I think they're very savvy now that she knows her rights and she has, advocates looking out for her. But it was really bad. I mean, I do think that they thought they were going to get rid of her. So I forgot to say at the beginning, we oftentimes see many people with vouchers, Jessica alluded to this earlier, who are also on disability. So that's a very common theme. And as you probably all know in this room, to have a Section 8 voucher, you have to be very low income. Okay, this is another case involving federal law and retaliation, but not a Section 8 voucher. This has to do with disability income. So this person on the right was our complainant, Harry Tyus, and on the left is our former director, Pam Kish. So Mr. Tyus had been living at Fairway Trails for a few months, half a year or something, before he contacted us. This was a while ago. This was in the early 2000s, I believe.
Yeah, it predates both of us.
Yeah, so we weren't, Pam worked on this case. But, so it doesn't, source of income discrimination doesn't have to be based on, Jessica covered this, just housing vouchers. It could be any source of income, veterans, disability, less common, but could also be child support, spousal support, things like that. So Mr. Tyus was getting his Social Security check on the 3rd Wednesday of the month. So later in the month, to the point where every month Fairway Trails was charging him a late fee, even though it was out of his control when he was getting his disability check. And so when you're on a fixed income, he was on disability, a $50 late fee every month is a sizable portion of, percentage of your rent and of your overall income. So it was having a detrimental effect on him. So he contacted the Fair Housing Center. I mean, he'd been asking for it on his own and they weren't responding. So we sent a letter, and I don't believe that they responded to us. Instead, what they did is they filed an eviction action against him. But in the district court, in the landlord-tenant action, the judge ordered the landlord to grant the reasonable accommodation to let him pay later in the month and to not charge him a late fee. So it's a waiver of a policy, a reasonable accommodation, just a straight waiver of their late fee policy is what he was asking for. And so the judge ordered it, and at the court hearing, the opposing attorney, the attorney for the landlord, was overheard. This was on the record, so it's really stupid on his part. Well, it doesn't really matter anyway. It doesn't really matter anyway because he's not going to be living here much longer. Like, they were not planning to renew his lease. That is a sign and evidence of discrimination. So Mr. Tyus initially took this, like Jess was explaining, through the administrative process first. He went to HUD. He had a good investigator, but they were not able to reach a conciliation agreement with the landlord. I think they offered him like $500, so an insulting amount. But the HUD investigator was good in that he said, why don't you go to the Department of Justice? Like, not the same circumstances right now. This would not happen right now. But at the time, he did. And so he filed a federal lawsuit and he was awarded $50,000 in damages. And this was a while ago, so that is a lot of money today and even more money in the early 2000s. Okay. So that is another example of retaliation. Okay, so.
Can I just add?
Yeah.
Just to point out that, a lot of people are fearful to come forward with complaints. They don't want to rock the boat. They, and obviously, keeping a roof over your head is most people's number one priority. But the law is on your side. If adverse action is taken against you because you tried to exercise your fair housing rights, the law is on your side.
Yeah. Yes. Okay, so this is the first case under the new Elliott Larson Civil Rights Law protection the first in the state of Michigan. It was very exciting. This was a complainant, Miss Burton, who came to us. It's very recent, like in February, I think, late January, February 26th. And she applied to South Grove Apartments. She had a Section 8 voucher. She had to leave her prior landlord pretty quickly, and so she was in a scramble to find somewhere to place her voucher. So she goes to South Grove, and they say, well, who's your voucher through? So she tells them the name of the provider, and they say, oh no, they're really slow, switch to this other one. And she said, I don't think I can do that. She was right. You can't just, the tenants don't have a right to pick and choose. It's not within their control. So they said, well, you can move in, but we won't take your Section 8 through that provider because they make us enter into third-party contracts, and we don't do that. I.e., we won't sign your HAP contract, just like Megan Moore's pattern, as I'm sure you can see. So, oh no, we accept Section 8, but they really don't, because they won't do what's required of the Section 8 program. That's mandated at the federal level from HUD. Every single MSHDA provider or any other, it applies in the whole country, whatever the public housing provider is for the state, they mandate the HAP contract. It's across the board. So she did move in because she was in a very desperate situation. She was scrounging, borrowing money to pay the first couple months of her rent. So we took a complaint. And one interesting thing is that this South Grove said that the place they wanted her to switch the voucher to, that they didn't require third-party contracts, which is clearly a lie, which we substantiated and have evidence of that. So she worked with a cooperating attorney of ours named Robin Wagner, and she filed a federal lawsuit against South Grove and the management company. And on
State.
what did I say?
You said federal.
Oh, sorry.
We're used to
I'm
doing
so used to
federal
saying
cases.
It's filed a state action, court action lawsuit in the Washtenaw Circuit Court, 22nd District Court, in downtown Ann Arbor. And on, what was it, April 29th, there was a preliminary hearing for, so not the full case, not just the very beginning of it, to immediately get this preliminary injunction, get them to stop saying they wouldn't take her Section 8 and forcing them to sign the HAP contract. So it was a big deal, and she did win, and the judge did enter an order saying that they had to do that. They had to do everything else to comply with whatever the Section 8 program required. And then as of May, at least we haven't heard otherwise, she didn't have to pay the full rent. She was only paying her portion, which she knew the amount. They just weren't letting her pay that. So we'll see where the result and the rest of the case goes, but it's a good sign, it's good momentum for the case. Okay. One emerging issue that we're seeing a lot, and I'd love to hear feedback from y'all, because I do think that this is one of the bigger issues we're seeing, at least. So I'm wondering if y'all are seeing this, which is income threshold issues. Like, well, we accept Section 8, but you don't income qualify. You don't earn 3 times the monthly rent or 2.5 times the monthly rent. And that would be impossible, because if they earn that much money, they wouldn't qualify for the voucher. So it's just some kind of history behind it. So initially, the L.A. Larson Civil Rights Act, the section on source of income protection of the L.A. Larson Civil Rights Act, was supposed to reflect or use as a model the Ann Arbor City Ordinance, which has, as you can see, this very precise language that any monthly housing assistance, or a voucher, let's say here, administered by a federal, state, or local agency shall be treated as income in the amount of 3 times the value of that monthly rental assistance. Very clear cut. Substitutes that requirement, basically. The voucher equals that, and that's it. That's would have been great, but that's not what happened. So what the legislature did when they were trying to create the law and draft the law, what they did was, there's a process first. You refer something to what's called the Legislative Service Bureau, and they told them to look at the Washington state law which is not as clear as Ann Arbor's, but certainly clearer than what we wound up with. So what they said was, any source of income in the form of a voucher must be subtracted from the total monthly rent prior to calculating the income criteria. So let's say the rent is $1,500 a month and the person's voucher is $1,200. You have to subtract that before you multiply it times the income criteria, the 3 times the rent, or 2.5. So what's this? $300 times 3. That would be the income requirement, $900. Now, because our law was drafted very broadly, this is what ours says. If the landlord requires a prospective or current tenant to have a certain threshold of level of income, exclude any source of income in the form of a rent voucher or subsidy when calculating whether the income criteria have been met. So what a lot of landlords are doing is they're not subtracting the voucher out first before they multiply it by the income criteria. They're doing it on the front end. So 3 times 1,500, then taking off the 1,200, that's $3,300. That's a huge difference between $900 and $3,300. And no one with a voucher would be making that. Plus, they're adding on any income that they have from work. So the whole point of this is not to really harp on the numbers, but the takeaway is if y'all are hearing this, like from clients or whomever you're assisting, where they're kind of consistently being denied from landlords because of income threshold issues, you should definitely call us. This is something that local advocates, attorneys, law clinics are actively looking for cases on this very issue. Because that language is so broad in our statute, it really needs to have some legal interpretation, some written decision on it. For lack of any legal precedent, there is talk, although not the greatest legal environment, or what do you call it, legislative environment now with the current House and Senate at the state level, but people have been talking about, well, if case law can't kind of help with the kind of ambiguity of how the legislation is written, is maybe going back and trying to appeal to have the legislation rewrite this part of the law. Anyway, so be just aware of this, because it is a pretty big issue right now that we're seeing in terms of how landlords are trying to get around certain protections. Because the goal of this law, as everyone knows, is to open up housing for people with Section 8 vouchers, and this hampers that. Yes?
So one up from Lansing, so this might contradict that a little bit, but and I have seen that too, but what I'm seeing, and it's like unclear what this was from, is there's landlords are citing fair housing and saying that because they have to treat everyone equally, they can't count the voucher at all.
Right. We
What
hear
is
that.
that?
We hear that too. That's a violation. That's just their way of trying to get around it. That is kind of what the lawyer in the state action in the Burton case that I was just talking about, that is kind of the argument that the landlord's attorney tried to make, and the judge was like, no.
So like in that case, we would contact you, you guys wouldn't have to do testing, you would just be able to.
Well, we may, but no, I mean, if they told your complainant that, and let's say we did do a test and it replicated that, I mean, that's pretty concrete. Yeah, so that's exactly what we're talking about, is situations like that. Yeah, because it's not treating them differently. The law is the sections of the source of income section, or L.A. Larson specifically says that you can't, that's treating people with the voucher differently. And you can't do that. You have to be able to count their income with the voucher and the rent, like how they intermingle. They're allowed to have inspections. There are certain criteria that they are privileged to have under the statute. They didn't have it before, but now they do. So that argument just goes against the language of the statute.
Can I ask one more question? Like, I don't understand, because they could choose not to accept Section 8, like, what is the benefit if they're like trying to screen people out? What
Well,
is
they
the-
can't choose not to now.
Okay, that's why I signed up for this.
Yeah, if it's, I think you missed the beginning part, if it's 5 or more units,
Yeah.
then they cannot deny it.
So
So
every-
formerly, landlords could say, well, we just don't participate in that program. But the state law protection now, if they're a qualifying landlord, i.e. they have 5 units or more, they don't have that right.
Thank you.
Yeah. And so we cover Ingham County, we cover your county.
Yeah, no,
Yeah, yeah.
I've actually, you guys have came and stuff.
Okay,
but-
okay, cool. Okay, so I think we kind of just did that. We want to hear from you. We want to hear about your, cases, your clients, your situations. If you think you're gonna, and you're in the midst of experiencing housing discrimination, or clients are. If you just have questions, this is obviously pertaining to not just source of income, all the protected classes as well. Contact us. If you're not sure if we're the right place to contact us, do it anyway, and we may be able to help you. We'll do our best to help you get in touch with the correct agency or organization. And just because you contact us or your clients do doesn't mean they have to file a complaint on the spot. Everything is confidential. There's no cost to file a complaint. There's absolutely no income qualification for our services. So just don't hesitate to contact us is the bottom line. And that is how to contact us. Yeah.
I'll just make a last plug. So
Yeah.
we are, well, a couple of things. One, we are doing a more comprehensive training this Thursday in Jackson. I know that's short notice, but so we do housing advocates training usually once or twice a year. It's a full day on landlord tenant law, fair housing law, and housing subsidy programs. Technically the registration ends tonight, but if you were interested, just let me know. And then the other thing is that social service providers and people working with the public tend to make really good testers. So if anyone's interested in becoming a tester and helping us investigate, it's flexible. We pay $31 an hour plus mileage.
We're always
You can
looking for
talk with any of
all,
us about that.
always looking for all demographics too.
Yeah.
So if
Or
you
if you
know
know
people,
someone, yeah.
then